Good afternoon, everyone, and welcome to our latest webinar on safeguarding contracts and dealing with uncertainty. Firstly, as I said, many thanks to you all for joining this webinar. We're particularly in these difficult times here, we are doing as much as we can to bring our clients, communities and colleagues and all our contacts together so to try and get through this crisis together. As such, if you've got any queries about what we say today, about any legal issues, is there any information you need or any connections we can actually make for you, please do let us know, and we'd be delighted to help, and we'll do all that we can. So without further ado, allow me to introduce myself and my colleague. I'm joined by John Paul Casati, who's my colleague from our Birmingham commercial litigation team, and he's an associate like me. My name is Rob Coleridge. I'm a senior associate in our commercial litigation team from Southampton. Without going any further, you'll note that JP and my hair is considerably shorter in those photos than they are at present. Like many of you out there, we have struggled to get haircuts over the next 6 weeks, so please forgive us. To try and make amends, we've both given ourselves slightly more appealing backgrounds than our makeshift offices for the last 6 weeks. I hope that's okay. Give us any feedback you may have. In terms of more of a generic housekeeping, many thanks to you who've submitted questions already. We will answer them. I think we're going to do so at the end of the presentation because we're going to cover a lot of the subject matter during the presentation itself. But if you have any further questions throughout the presentation, please do submit to us via the Q&A function you should see on your screen. We will get to them at the end. We're also going to be recording this as a virtual event and sending you copies of the recording afterwards. So if you don't get to make notes, don't worry, you'll get a copy at the end. But as I said, if you've got any queries, just ping us an email and we will get back to you. If unfortunately the event is stopped or cancelled midway for IT reasons or anything, which shouldn't be the case, which you're not expecting, don't worry, we'll record it separately and send it out to you as I said we usually before. And again, let us have any questions and we'll get back to you. Before I go any further, the other thing I wanted to mention was that from our attendee list, we can see that you come from a very wide range of backgrounds and sectors and levels of experience as well. We are going to try and therefore speak to a kind of relatively common denominator, but if you've got any specific questions, no matter how advanced or level it is, please do, as I said, use the Q&A function or email us afterwards, and we will absolutely come back to you with an answer. So, moving on to the content of our webinar today, it doesn't need to be said that these are difficult times for everybody. There's a hope that restrictions are going to be lifted and we will be able to return to business, but I think we're going to be in a difficult situation for quite some time, years potentially to come, given the situation. Now, in any time of uncertainty, previous recessions or any times of uncertainty in a specific area, it can lead to difficult situations, which we need to protect ourselves against in terms of business relationships and business contracts. But it also leads to opportunity to refresh and revisit those contracts. And what we're seeing in this particular situation is the real community spirit, people coming together as an understanding of the difficulty that everybody is under. And therefore it does represent an opportunity for parties to work together, as I said, to refresh their relationships and revisit how they can work together better in circumstances. So what we're going to try and do to you today is to give you some ideas about what you should be looking at in terms of your business relationships and how you might be able to, what you need to check for, what you need to look out for, and how you might be able to adapt in order to be able to get through these difficult times. So just in terms of a kind of order of things, JP is first going to talk about understanding your contracts. I'll then talk about the key contractual terms. JP will then move on to how you can change and adapt your contract situation. And then lastly, I'm going to talk a little bit about maintaining your relationships and protecting your reputation. So without further ado, I'll hand over to JP, who'll take you through understanding your contracts. JP.
Okay, thanks, Rob. So the starting point in understanding your contracts is to first of all establish whether or not you have a contract in the first place. Many people view a contract as being a single document with a load of terms and conditions which have been agreed and signed off on. And that can be the case, but there's also many other ways in which contracts can be formed. They can be made verbally and they can be made through a series of correspondence, emails and the like. What is important is that any contract has 4 key elements. The first element is that there has to be an offer and acceptance. So one side makes an offer, the other accepts it. The second point is that there needs to be consideration on both sides. So essentially what this means is that both parties need to bring something to the agreement. The most common form would be that one party is going to provide a service, the other party will pay for that service. The third point is there needs to be an intention to create legal relations. So it must be clear that the parties are intending to enter into a contract. A social arrangement, for example, would not constitute a contract. For example, some people in one claim tried to show that a carpooling arrangement whereby one party was paying for petrol and the other was doing the driving formed a contract, but the courts found that that was not a contract because there was no intention to create a legal relationship. And finally, there needs to be certainty of terms. So the type of arrangement whereby 2 parties agree that at some point in the future they may start to do business but don't hammer out any specific terms or timeframes or prices would not constitute a contract. That would be considered to be an agreement to agree and wouldn't be enforceable as a contract. So provided the agreement has the 4 key elements, offer and acceptance, consideration, an intention to create legal relationships and certainty of terms, you will find you've got a contract. As I mentioned, the form of the contract can vary. In many cases, you'll have a nice clear-cut document with all of the terms and conditions clearly stated, negotiated and signed by both parties, or more than 2 parties if that's the case. However, a contract can just as validly be formed through a series of correspondence. Often you see the type of scenario whereby people exchange emails, talking about the type of good that's being provided, the pricing, the timeframes, all in a series of email chains or letters, telephone calls. Often these emails may provide links to websites with terms and conditions on them. Purchase orders may have some terms and conditions on the back. Invoices also may have some terms and conditions. So if you have this type of scenario, it's really important to review all the documents, all of the correspondence, see what might be missing and assess what you do have. One particular problem that arises in this type of contract is understanding which terms you've agreed. So for example, if 2 parties are sending emails to each other and attach copies of their standard terms and conditions, quite often you might have what's called the battle of the forms, where the parties can't decide which set of terms and conditions have been agreed. The general rule of thumb is that the terms and conditions that were last sent prior to substantial performance of the contract are the terms and conditions that will apply. However, it's very important to carefully check all of the correspondence to see what has been agreed. And finally, contracts can be formed verbally. A contract does not have to be in writing. A verbal contract is binding. The only problem with verbal contracts is that they're more difficult to evidence. Obviously, by their very nature, there won't be any documents or objective criteria which you can look at to decide what has been agreed. So once you've had a look at your contractual documentation, you also need to consider whether there are any other terms that can be worth considering. So I'm talking about implied terms. So the law implies terms into contracts. For example, if you have a contract for the sale of goods, there will be an implied term that the transferor or the seller has good title to those goods, so that they actually are capable of selling those goods. Also, that the goods are of a satisfactory quality and fit for purpose. So this is important if there is nothing in the contract in the way of express terms explaining what criteria any good has to possess, what qualities it needs to meet. In this case, you can rely on the implied terms that the goods should be of satisfactory quality and fit for purpose. Also, in contracts for the supply of goods and services, which could be very relevant in these times, there will be implied terms that the services supplied should be supplied with reasonable care and skill, and that the services should be supplied within a reasonable timescale. So it's often difficult to understand what might be a reasonable timescale in the current circumstances with so many unusual factors arising, but it's something to consider in all of the terms of the contract. So if there isn't a specific time or date by which performance has to be made, then the default position is that it has to be made within a reasonable timescale. So I think when you're looking at your contracts and any kind of disputes or issues that might arise, I think the starting point is to give yourself a bit of headspace, a bit of time, sit down, go through your documentation, your emails, your correspondence, assess what documents you have, what might be missing, whether implied terms would help you, or what might hinder you and where you might be vulnerable. And then from that point, you can start to consider how you approach the other side. I'm now going to pass over to Rob, who's going to take you through some of the more key specific terms and conditions which you might find in your contracts.
Thanks, JP. Okay, so as the slide says in front, I want to have a look at some of the key terms which you should really be looking at for the purpose of reviewing contract, either to make changes or to make sure that throughout these difficult times you are doing what you're supposed to be doing and is the same for the other side. So I want to initially look at, to be honest, the core obligations of the parties. It may seem obvious, but I think it's important when you're looking at your contract to look at what you're supposed to be doing, what the other side is supposed to be doing, and whether you're actually doing it. Whilst in many contracts we see, this is probably where most time is spent on setting out what the parties are supposed to be doing and or paying for it. A lot of the problems we see are where there's been some form of scope creep, and therefore where parties have moved beyond what they're supposed to be doing, and therefore there's just a question about how much they can charge for that or what should be done about that type of work. Also have a look at timing. Have a look at when you're supposed to be performing, and also have a look at how long the contract is supposed to last for. In terms of timing, there are issues about, for example, whether time is of the essence, whether a service is supposed to have been delivered by a certain point. Even if time is not stated as being at the essence, if specific dates are mentioned and you miss those dates, your business is at risk in terms of missing that deadline and giving the other side the opportunity to potentially terminate that contract and bring a potential claim against you. In terms of the general length of the contract, one thing we also see a lot of is where a contract it has a fixed term and it's then moved beyond that fixed term and the parties are continuing to comply with the same contract and do the same thing for another in terms of payment. So in those situations, you need to be looking at what happens when the contract is brought to an end. Can you bring the contract to an end? You need to understand what the position is in terms of both the time of your obligations and the length of the contract overall. Pricing is obviously the last kind of fundamental term of these contracts here. Most contracts will provide for some form of fixed price, but some contracts will also look at a fluctuating price range, whereby your price can change according to the circumstances, particularly in terms of raw material price or other factors that may influence performance. So if you are in difficulty, have a look at the contract to see whether there might be that ability, or alternatively approach your other side to see whether that kind of mechanism can be negotiated in terms of variation, which we'll talk about a little bit further. So the next question I'm going to talk about, and the next series of terms I'm going to talk about, are more going to be about the terms that operate really when times get difficult, when performance starts to become a problem. And the first term naturally to talk about now is breach of the contract. And a lot of contracts contain terms about what's called material breach. What comprises a material breach of the contract? Now, a material breach of the contract, you really, and generally speaking, is a term which goes to the core purpose of a contract. If you're providing a product of a specific design, it could be making sure the product complies with that design. If you're providing a set number of goods, it could be making sure you provide those goods, or if you're providing a service to a time, making sure you provide with that time. And it'll give a set out a procedure, a process of what happened on material breach, which may include termination. Now, in those circumstances, the first thing you need to look at is firstly to work out, as I said, what represents a material breach. And ideally in these situations, what you would see is you would see a clause which refers back to specific obligations of the contract, which the breach of which would be a material breach. So, for example, if you are required, as I said, to provide goods of a certain description, the clause might say, in the event of breach of clause 2, that being said clause, that represents a material breach on which the party not in breach may terminate the contract. Have a look at those clauses, make sure you understand them, and make sure you understand the risks and where the real termination risks occur. As I said before, those kind of references to prior obligations are not necessarily included, and therefore you also need to think about what obligations might go to the core of the contract, and therefore you need to be mindful of in the event of an existence of a clause of that nature. The last thing worth pointing out with regard to material breach is that if such a clause exists in the contract, repetitive minor breaches might also represent a material breach. So be careful about performance in that regard. Moving logically on, the next consequence to talk about is obviously the termination of a contract. Most advanced contracts tend to provide some form of clause about the termination, about how parties can terminate and in what circumstances. Breach is a classic circumstance, but some contracts don't necessarily refer to material breach. They may say any breach of contract can give a party a right to terminate. So again, be careful of that and make sure you understand your position. If you do have that right, or if the other side has that right, pay particular attention to what needs to be done in that circumstance. Does notice need to be given to the other side? Do you need to give the other side an opportunity to rectify that breach? Contracts can be carefully worded so that the process has to be followed in the event of an event giving rise to a termination opportunity. So make sure you understand that. The other type of event which commonly gives rise to the opportunity to terminate tends to be an insolvency type event. And we're talking about events not beyond a company being placed into administration. It could be a failure to pay any major creditors. It could be a bank taking any particular action. Make sure you understand and read those clauses carefully so that if your company or the other side's company is under any financial stress, you know your rights in that regard. Now, the absence of a termination clause, it's important to say, doesn't deprive a party of the right to terminate. Any party can unilaterally terminate a contract in the event of what's called, in legal terms, a repudiatory breach. Now, repudiatory in real terms means a breach that is so severe that it goes right to the heart of the contract. Now, I would not advise parties, generally speaking, to rely on this. It's a legal mechanism because a lot of disputes can arise as a result of it. If you terminate on the basis of what you think is a repudiatory breach, and it subsequently turns out that that breach is not sufficiently severe, you can be in breach of contract yourself, which leaves you in a very difficult position. Therefore, be very careful if you intend to rely on that kind of process. But you do have a right to terminate if you need to. Alternatively, of course, any parties can get together and terminate a contract by consent. No matter what the terms of the contract say, if you come together and you want to terminate the contract and there's widespread agreement about that, then the contract can come to an end in that way. So what happens when there is a breach or a termination and one party is potentially liable to the other? Well, in that circumstance, it brings us to the next clause, which is limitation clauses or exclusion clauses, which may purport to limit one party's liability for any particular breach or other action. Now, these clauses are quite widespread. It's important to say right early on, many of you will know this, that no party can exclude liability for any death or personal injury, but there are a huge other range of losses which they can exclude or limit their liability for. And all such clauses are subject to what's called a test of reasonableness under the Unfair Contract Terms Act 1970. Now, the lawyers amongst you will know that is a nightmare piece of legislation due to the lack of clarity in terms of what is reasonable and what is not reasonable. I'll go into some of the factors in a second, but those tests can be held to be unenforceable. So if you want to rely on such a clause as an offending party, or you want to try to overturn those clauses, there are risks and opportunities alike. Also, be mindful of the fact that limitation clauses and exclusion clauses are not necessarily obvious. They can be built into other key obligations as sub-clauses or as sentences sneaked in there at some point or not. A force majeure clause is in effect a limitation clause. I'll talk about more about that in a minute, but they can find their way into various different parts of the contract and may not be obvious. Therefore, have a look for them. If you see words about excluding, limiting liability, read those words carefully and see what they amount to. So going back to whether these clauses can be overturned, I just want to make clear for the lawyers, as I said, there are quite a few amongst the audience, that the old rule of contra preferentum, you may know, is largely now dead. the courts now look at these clauses in a much more purposive approach, looking at the words, the natural order meaning of the words actually used. And so if you want to overturn a clause on the basis that the other parties rely upon it, you think the court might come down in your favour, that's not going to happen anymore. The court will look at the clause much more objectively. And when it is assessing this clause, it will, however, look at many of the position at the time of the parties when negotiating that clause. In that regard, it's also important to bear in mind that if, with hindsight, you think a clause is unfair, the court will have little sympathy for that position. The court's always going to look at the position that the clause was negotiated or agreed between the parties. And so it'll look at their respective strength of their bargaining positions at the time. It'll look at any inducements to agreeing to general terms or the clause itself. And we'll also look at one party's awareness of the existence of the clause, particularly in B2C type contracts, where such clauses are covered not only by the Contract Terms Act, but also by the Consumer Rights Act. And looking at the difference between B2C contracts and B2B contracts, it's also worth pointing out that limitation or exclusion clauses, in the case of B2B contracts, the courts are notoriously reluctant to overturn them. Where there's been an element of negotiation, that's certainly the case. But it can be difficult to overturn them. B2C contracts are in a different position, where the court will much more take into account the position of the consumer in negotiating that clause. And so where terms and conditions are simply been imposed onto a consumer, there is a greater risk of it being overturned by the court for being unfair under the Consumer Rights Act. The other thing to bear in mind, particularly in B2B contracts, is the availability of insurance. Apart from obviously difficulties with taking insurance for a viral or disease practice now with insurers, the insurance market remains open, and it is possible for parties to get insurance for a range of different events. And particularly where one party may point out the opportunity to get insurance for a particular part of loss, the courts will be more reluctant to overturn a limitation clause where that is the case. If you are trying to incorporate or introduce a limitation clause into a contract, the better way to do it these days is by looking at the categories of loss you may suffer. In the past, parties tend to have looked at introducing kind of quite vague and opaque legal terms as indirect loss or consequential loss, which are quite widely interpreted generic legal terms. And these days, we find that limitation clauses are much more effective when they're more business orientated. So if you want to incorporate loss, think about the types of losses which you may affect your business. Think about business terms like anticipated profits, loss of revenue, loss of goodwill, loss arising data. All of these are tangible elements of loss which are easily interpreted by anybody working in a business. And there's a much better way to frame a position in terms of limitations or indeed any part of a contract. I'm going to talk about two more things quickly. I'm going to talk about force majeure a bit now and dispute resolution. So force majeure clauses, you would have seen a lot about these recently as a result of the COVID-19 crisis, because of the fact that the crisis is unprecedented in its occurrence and represents a situation which force majeure is intended to apply to, which is a situation beyond the control of the party. Now, we've seen a wide variety of force majeure clauses, and they can be drafted as widely as you like them, in essence. There could be some obligations where parties are simply, their obligations are limited, and it can be clauses where both parties' liabilities are completely excluded. But they also could be fairly one-sided, in the sense that I have seen clauses where one party's obligation to perform its services is limited or excluded, but the other party's obligation to pay remains despite the force majeure position. So these clauses can be widely drafted and widely construed, and they are, going back to the limitation points, also subject to test of reasonableness under the Unfair Contract Terms Act, so they can also be overturned if they are unfair. It's important to mention with force majeure clauses that if they do exist within an agreement, then the possibility of arguing a frustration event, which is something I'll talk about in a second, is pretty much gone. If it's addressed in the contract, then frustration tends to be out. But we're going to cover these in a subsequent webinar, but it's important to mention that these force majeure clauses can help, but to be careful about how they're drafted and what obligations or limitations they expose the parties. The last point I'm going to talk about is dispute resolution clauses in terms of the contract. Now, whenever there are contractual difficulties, parties can quickly refer to lawyers about what they, how they respond, how they deal with that. But that doesn't necessarily mean that you can't set out a procedure between you that you have to follow to try and resolve any difficulties before lawyers are involved, at least on an open basis. Quite carefully framed contracts and quite carefully framed dispute resolution clauses can set out a process by which parties can go through to try to resolve a problem. For example, they might impose an obligation on the parties firstly to meet, discuss the problem and try to resolve the problem behind closed doors or on a without prejudice basis, so it doesn't affect their rights, but it gives them a forum to discuss their problem and try to resolve it. If that doesn't work, the clause might then refer the parties onto mediation, which is a process by means a potential settlement or resolution is facilitated by a third party, the mediator. He doesn't make any rulings about anything, he helps to resolve the problem. And lastly, the parties then may want to move on to a more formal process, which could be in the form of court proceedings, or alternatively, it may be arbitration, which of course gives them privacy in terms of resolving any dispute and therefore potentially protects parties' reputation, or any adverse effects to the reputation which may arise. So I hope that's helpful in terms of some of the clauses which you might want to look at. I have been asked to have a look at frustration as well, because frustration is typically the kind of a legal doctrine which tends to apply in circumstances when there is no contractual term to deal with that situation. Frustration is a doctrine where a circumstance arises which has not been anticipated by either party, which properly prevents both parties from being able to perform their sides of the contract. Now, in that circumstance, the automatic corollary of it is that parties declare void and any payments should be refunded to the other party, and there's no obligation on the other party to perform the circumstances. Now, there are slight problems with the situation as arising as a result of the Consumer Rights Act, which I'm going to come on to slightly later. But there is an opportunity in B2B contracts whereby if a contract is frustrated, as I said, absent any contractual provision, if a contract is frustrated, then where money has been paid in advance, if the payee, the person who's received the funds, has actually incurred any cost or done any work on providing that contractual service, they can keep that money back in order to try and protect themselves against costs they incur. So I hope that's helpful. I have got a question about this, but if I don't mind, I'm going to come back to that at the end of the webinar, and I'll answer it then. So I'm now going to pass on to JP to talk about how we are going to vary the contracts and introduce some of these terms that don't already exist.
Thanks, Rob. So I'm going to speak a little bit about variation, which is and can be a real minefield, which can give rise to a variety of disputes if contracts aren't varied in the right way, or if mistakes are made when negotiating variations. So the starting point, as with many of these things, is to have a look at what's in the contract. Whether the contractual documents allow for a variation, and if they do, how that variation can be made, and whether there's a process that needs to be adhered to. One thing to look out for in particular is whether your contract has a no oral modification clause. So a no oral modification clause will be something that reads along the following lines. No amendment or variation of any of the terms of this agreement will be valid or effective unless made in writing and signed by the parties. So what that does is prevent the parties from making verbal variations or amendments to the contract. If the parties wish to vary the contract, they have to agree in writing and sign, and both parties have to sign. There's a quite interesting case, which I think is quite pertinent now, which was decided by the Supreme Court a couple of years ago on these no oral modification clauses. It involved a company called Rock Advertising, which was renting out some serviced offices. Rock got into a bit of trouble and sought to arrange a new payment agreement with the managing agents of the building. The representatives spoke about the arrangement. An arrangement was agreed, which involved a payment holiday followed by further payments to be made. This was agreed over the phone. Rock did make the first payment under the agreement. However, the managing agents then sought to enforce the terms of the contract, the original payment process, claimed that Rock owed them money because it had missed payments. It then evicted them from the building and changed the locks and demanded full payment of the entire license agreement, so the entire license fee. This went through the courts, and the court sided on the side of the managing agents. So the managing agents were entitled to rely on the no or modification clause, even though a payment arrangement had been agreed verbally between the parties. I think at these times this is quite a cautionary tale, because lots of businesses will be suffering and will be struggling with cash flow. So if you're in a business, you're running a business in that kind of situation, and you want to arrange a new payment plan, I think it's extremely important to get that down in writing and agreed, as otherwise, if you fail on that, the other party can revert to the original contract. So that deals with cases where there's a no or modification clause. If you don't have such a clause, and if you're dealing with the types of contracts I referred to before, where things have been agreed by correspondence or verbally, you're unlikely to have something like that in your agreement. And in those cases, it is entirely acceptable to verbally amend or vary a contract. A contract may also be amended by conduct. So, for instance, if one party delivers goods late, then it's entirely acceptable that the other party might make payment at a slightly later date. A waiver by one party is unlikely to constitute a variation. So, for example, if one party accepts one late payment, that's highly unlikely, if not impossible, to have created a formal variation of the terms of the contract. One thing to consider is if the variation of the contract goes to the root of the contract. So if the variations are so fundamental to the nature of the contract, it may be considered that the contract hasn't been varied, but that the original contract has been rescinded. Basically, it's come to an end, and the new variation constitutes the entire agreement between the parties. So that's something to consider carefully, because if you have such a substantial variation, you may wish to ensure that all of the terms of the contract, the previous contract, are brought forward into the new variation, as well as the key terms that you're actually varying. It's very important to note as well that if you do not vary a contract correctly, then this could lead to a breach. So, for example, if you're in the middle of negotiating some terms and a variation, but then you go ahead and act on that variation before it's agreed, the other party could accuse you of breaching the agreement and could seek some further damages from you. So when you're negotiating variations, we have a few top tips to consider. The first would be to mark written communications as subject to contract. So that would state that the variations don't come into force until the agreement or variation has been agreed by way of a contract or deed. And that leads on to the second point. Even if there is no oral modification clause, if you are varying a contract, it's probably better to agree that variation in writing by way of an agreement or deed if necessary. It's also helpful if you link the documents together. So if you keep the variation together with the contract, or you append it to the contract so that everything flows together, and you just for practical reasons, you don't have a number of documents in different places. And finally, just as I mentioned before, be very careful when you're making these changes that you avoid breaching the agreement, or if you inadvertently vary the contract before you're ready to do so. So as I say, think very carefully about negotiations, look at the contract, see what the contract provides for in terms of variation, and then approach the other side to negotiate these variations. I'm now going to hand over to Rob, who's going to sum up and conclude our presentation.
Thanks, JP. So I just want to, at this stage, to talk a little bit about our experience in managing these disputes and how they are constructively resolved. Obviously, the title is Maintaining Your Relationships and Protecting Your Reputation. And this is really about how you constructively resolve these disputes. So the first point here really is about aggression. Our experience as litigators is that adopting a highly aggressive stance is rarely effective unless you have the legal basis on which to adopt that. If you don't have that legal basis, and in many cases, a dispute tends to arise because there is a lack of clarity and therefore a lack of legal certainty about positions. These things are much better resolved where parties can at least adopt a more constructive approach to resolving it, and therefore doing so in a commercial, more pragmatic way. That may involve the use of lawyers, but it may not. You may be able to avoid that cost. And I recognise I'm doing myself out of a job here, but it's worth recognising. In trying to resolve a dispute, obviously, try and focus on ascertaining what the other side's objectives are. We often see situations where, for example, a breach of contract may be asserted by one side, but in reality, what they're really trying to do is simply get out of the contract, trying to find an excuse to get out of it. And therefore, recognizing that as a non-price objective and trying to get to the bottom of it, be it by asking questions, be it by speaking to the other side without prejudice, or behind closed doors, or on a free basis, might help that conversation. It's worth keeping those conversations going, keeping those channels of communication so you can get to the bottom of what is driving any particular difficulty or dispute. When you are thinking about trying to resolve a dispute, try to think laterally. When you are resolving a dispute, you can do so however you want. You are not necessarily bound by the confines of a contractual position. You can resolve a dispute however you want to. We would also advise that when you resolve a dispute that's been a difficulty, try to crystallize, set out whatever has been agreed in writing. If you need to start the contract again, set out new terms and conditions. But in doing so, make sure you refer back to the dispute, make sure you agree whatever has been agreed about settling that dispute, or in terms of any payments, or in terms of whatever you agree. But in terms of what you agree, going back a step, you can agree whatever you want as part of the settlement. And bear that in mind, because it's important, because once you get to a court position, the court itself will only operate within the confines of the law and of the contract. It won't be able to think more laterally. But as a settlement, as I said, between parties, if they're trying to resolve it, they can think more widely, and it's important to try to do so. Lastly, I would say about resolving a dispute is, and particularly in terms of reputation, is that be careful about what is said to third parties, be it privately or publicly. As I said, difficult situations could lead to increased tension between the parties, but the laws of defamation still apply. And if you start saying things that may be conceived to be defamatory, firstly, it'll exacerbate the position, but also it may give the other side further ammunition against you, and it's not worth doing unless there's a very strong cause to do so. That is not to say that it's a tactic which you can't redeploy. However, it needs to be deployed very carefully, and once it's done, it can't be undone, so to speak. So be very careful about that and think about your reputation, think what that would do. As I said, think constructively, think widely, and be careful what you say to others. Now, that brings us to the end of our substantive presentation on this. We have got a few questions already which we need to answer. Thank you for submitting those to us. But if you've now got any other questions, as I said, please do use the Q&A function, and we will get round to them as quickly as we can. So the first question I'm going to look at is one which has been submitted just by Chris Snell, who has said that we are a wedding venue. Are our couples in a position to demand their money back if we are offering postponement to an alternative date next year? Are our contracts frustrated if weddings cannot take place? So, Chris, the first thing to say to that is, after this, we will send you details of an article which has been published by a colleague of mine, Catherine East, specifically on the troubles facing the wedding and events industry at the moment. And if you want to speak to her in great detail, she'll be delighted to help you. But in short, the position regarding wedding venues is a difficult one. Going back to the Consumer Rights Act I mentioned earlier, is firstly, if an event cannot be held on a date due to the restrictions in place, then I think the answer is yes, it will be frustrated, and you will. But that means that you would, by default, be obliged to give them a full refund under the Consumer Rights Act. Now, the reason for that is under the Consumer Rights Act, if an event or a service is to be provided at a specific date, then, and it cannot be provided at that specific date, then the consumer affected has a right either to ask for a refund or to require the service to be provided at an alternative date at their convenience. In other words, the right is with the consumer either to ask for a refund or for a date. Unfortunately, that means that if you insisted upon the wedding taking place at a different date and deprive them of a right to refund, I think they would potentially have a claim. That said, that particular provision of the Consumer Rights Act may be interpreted differently by the courts. There's bound to be a litigation about this, but I think for the time being, I would say regrettably that you are in a position of risk at the moment. And if you can work with explain this to your clients and customers and try and work with them as much as you possibly can, then hopefully they'll achieve a way forward. But if you've got any problems or other queries, do let me know. JP, I think you had a question about the courts.
Hi, yes. The question I received was, are we likely to see CMC's disclosure and trials delayed into autumn or spring 2021? The short answer to that is that the courts haven't actually stopped. The courts are endeavouring to continue with their business. Many hearings and even trials are taking place remotely via the various platforms like this one. However, there has obviously been some disruption. Hearings which are not considered to be essential are being adjourned. Certain types of claims there's a certain moratorium against possession claims and insolvency claims at the moment. Parties are very much being encouraged as well to take a sensible view, not to try to capitalise on another party's maybe delays or failure to meet a deadline, and to act sensibly and to extend deadlines where appropriate. So the answer is that the lawyers and the courts are trying to maintain business as usual, try to get things done. We're all learning different ways of working at the moment. Much more is being done remotely, but there may be some disruption, and you could see hearings being pushed back a month or so, but hopefully not too far. And actually, one other further point on this, there are some regular updates coming out from the courts, which you can find on the gov.uk site. So they're listing, in some cases, there are some courts which are closed and some which are operating reduced hours, and you can find those details of specific courts if you are working on a particular case in a particular court on the government website. So we've had a few questions now popping up. Rob, you mentioned the force majeure one. Would you like to take that one on?
Sure. Okay. This question is come from one of our attenders, and they've asked, do you think a customer can invoke force majeure simply because they are unable to operate, for example, due to COVID-19, when their only obligation to a service provider is to pay, which is not affected by COVID? Let's assume there is no practical COVID-related external reasons why they cannot pay aside from the declining revenue, and this is a B2B contract. In answer to that question, it really does depend on the terms of the force majeure clause in question. If there isn't a force majeure clause, and we're talking about a frustration argument, i.e. the parties haven't anticipated this, there's no contractual provision for COVID-19 or any sort of situation, and the customer saying, I'm frustrated from paying you. Our view is that when it comes to payment obligations, that is not an event which causes a frustration situation, simply because it has to be the actual performance of the obligation which is prevented by the relevant event. Now, payment, unless, for example, the bank were to have financial difficulties itself, it would be impossible physically to make the payment. COVID-19 is unlikely to be construed as an event amounting to frustration. If, on the other hand, you're relying on COVID-19, for example, the ability to put on a particular service, the restrictions are in place, are you physically, it's illegal for you to put on that service. But that is a classic event of frustration. There are different consequences of that, as I've alluded to in answering the previous question, but it is a frustrating event. Going back to whether a customer can actually invoke force majeure, again, it is an area of the law which depends expressly on the wording of the force majeure clause in itself. And I think you need to look carefully at that wording and see what are the parties' obligations upon a force majeure arising, what it says about that. Again, it depends on the wording of the contract itself. And in doing so, you need to look at the kind of natural and ordinary meaning of the words, the relevant words, and also what it was intended to do at the time it was entered into. I hope that's helped. But if you want me to have a look at the clause itself, please do contact me separately, and I'd be delighted to have a look and give you a view. So we've got another question coming from another attender about what changes do you think we are likely to see as a result of COVID-19 in terms of standard terms to be incorporated into contracts, in particular commercial leases. I'll give you my view on that. I'll let JP give you his view as well. I think this is going to be interesting. I think that generally speaking, prior to COVID-19, there was already a trend about standard terms being incorporated into both commercial property leases and commercial leases for equipment. The law as to kind of when standard terms are incorporated and when they're not incorporated into them remains the same. They've got to be clearly brought to the parties' attention. There may be an issue with regard to battle of the forms. But I think that as a result of COVID-19, in terms of where capital, retention of capital and access to capital will become more of a key issue for any business, so that they have the funds, access to funds to weather any incoming storms, will become a more common way for business to operate, and therefore they tend to gain access to equipment on a lease hire basis more than any other way. And where there is an increase in business, there is naturally an increase in standard terms being incorporated in those types of agreements. So I do think that standard terms are likely to be more commonly used in leasing arrangements. Whether that applies to real estate, I think there was definitely a trend in that direction. I'm not a real estate lawyer, but I can certainly refer you to someone if you want to have a discussion with them, and hopefully that's helpful. So, JP, would you have anything to add to that?
Hi, yeah, no, not too much. I mean, it's a really interesting question, and actually I don't have the answer. But, you know, thinking about it, I think one obvious thing is that people will start to put force majeure clauses into their contract and make sure those force majeure clauses refer to pandemics. People may also, having been burned in these situations, think a little bit about their dispute resolution clauses. I'd like to think they would. But in the event a force majeure arises, what people need to do to try to work together to keep agreements alive. That would be hopefully a sensible thing to start thinking about. People may go the other way and start thinking, well, if this, you know, we have a pandemic, then all bets are off and we're both entitled to terminate with immediate effect. So it's certainly something that people are now going to bear in mind, because I think beforehand, if you thought about force majeure, particularly if you live in England where we don't have typhoons and earthquakes and things like that, you think it's something you put in that's probably never really going to come up. But now this has happened, I think people will pay a lot more attention to that, and it will depend on the circumstances of your agreements as to what you might come up with. But it is a really interesting question and something I want to give some more thought to. And as Rob said, we're not property lawyers, so I don't really want to start going into commercial leases. But if the question's been submitted anonymously, but if you email us afterwards, we're happy to put you in touch with one of our colleagues in the relevant team. And I think that's all from me. And I think that's all the end of the questions.
Right. Okay, well, I think that wraps everything up. As I said at the beginning of the webinar, if you've got any questions on reflection or with hindsight, please do let us know. Our emails are on screen now, and we'll let you have a copy of the webinar and the slides afterwards. I hope you're all well. I hope you stay safe throughout these difficulties, and that your respective businesses are in a good position to make a strong comeback as we emerge from this, and hopefully to a brighter future. Many thanks to you all, and hopefully I look forward to working with some of you in the future. Many thanks.